Jamie Cottingham present? Yeah. Now the record of the matter of the people of the state of Michigan versus Jamie Renee Cottingham, file number 24-00899, SM, council appearance.
This is the prosecutor speaking on behalf of the people.
Assistant Public Defender John Lee, attorney on behalf of Jamie Cottingham.
The case date and time that was scheduled for a pretrial or final pretrial for an assault and battery was previously no offer extended, and that's still the case.
For Ms. Cottingham, no, the offer that was extended was for Cottingham to plead guilty to amending count 1 domestic violence with 76948 eligible. However, the necessary witness has still appeared this morning before any proceed trials.
I have a bond violation here. Right. We need a copy of the report for the bond violation. Make sure you get a copy of it. It's dated April 7th, 2024. Allegations from the police report is that the protected party, who is a long-haul trucker and on the road, allegedly received contact by the accused brother with threats, and also received messages from the accused sister via Facebook. I would like the prosecutor to retrieve that evidence to arraign you on a bond violation. Bond violation is a contempt of court order. If you're found to be in violation of the order set by the court as to your bond, you're subject to a penalty of 93 days in jail and/or a fine of $7,500. Okay. So the allegations are that you violated your bond by making indirect and direct communication with the protected party. I think the report also states that there was direct communication between you and the alleged victim. So you have the right to have a contested hearing. You have the right to be by your attorney at that hearing. I'd advise you of the maximum penalty if found to be in violation of your conditions of release. Do you have any questions about that? How should I find to proceed? Well, you haven't received the report. I'll go ahead and plead not guilty. We'll get you a copy of the report. We'll make sure that one's forwarded to you as well as the prosecutor. And the prosecutor will make arrangements to get in contact with the alleged victim. There is information in the report that includes both an email and a mobile phone number that also indicates that the victim is a truck driver. So I will require the prosecutor to let us know if the date set conflicts with that within a reasonable time frame. And you can reset the final pretrial June 18th at 8 a.m. in person.
Your Honor, so does this mean that the complaining victim will have another opportunity to appear then?
Absolutely.
Okay. I have another question, Your Honor. My client needs access to the home. She has personal property there that my hard understanding is in danger of being thrown away because the complaining witness has forwarded notification that he will be leaving the premises within the next couple of weeks.
Forwarded notification to who?
My sister, hon.
Where's the notification?
She sent me an email.
I can see it.
Okay. Forwarded the email to you and Ms. Nash.
Okay, I will go off the record and I'll review that when I get a chance. You have a seat now. On the record in the matter of the people of the state of Michigan versus Joseph Ellen Boss, number 23-03399 and 24-00062. Council appearance, please.
Assistant Public Defender John Lee on behalf of Joseph Ellen.
Okay, today was the date and time set for final trials on both matters. How we proceed?
It's my understanding that Mr. Ellen Moss will be accepting the offer that are offered to him. The offer is for Mr. Ellen Moss to plead guilty as charged to malicious destruction of personal property less than $200 in file number 23-03399 and agree to pay restitution totaling $846.54 and forfeit the firearm, and we would dismiss case number 24-00062. And I have a plea sheet and a restitution sheet here. Okay, I have an advice of rights and pay information sheet present and the plea sheet. You heard the offer that was extended, Mr. Ellen Boss.
Yes, Your Honor.
You want to accept that offer?
Yes, I do.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Okay. Did you read this document?
Yes, Your Honor.
That's your signature?
Yes.
You understand all the rights listed here?
Yes, I do.
You want to give up all of these rights?
Yes, Your Honor.
So you have the right to the presumption of innocence. You're innocent until proven guilty. You understand that?
Yes.
You want to give up your right to be proven guilty?
Yes, Your Honor.
You have the right to see, hear, or question any other witnesses that the prosecution intends to call against you. You have the right to remain silent at trial, not have trial silence at your trial be used against you. Or you can waive your silence and testify at your trial. Or you can subpoena witnesses to trial to testify on your behalf. And also present evidence that you believe show defense to the charges being brought against you. So you want to give up all of those rights as well as your right to a jury trial, correct?
Yes, Your Honor.
You right need to give up those rights.
No.
Has there been any promises made in exchange for you entering a guilty plea today?
No.
Are you currently on probation or on parole?
I am currently on probation
Out of what court?
from this court, Your
What judge?
You.
And so when?
Honor. It is a 12-month probation. It began last month. I cannot call the exact date.
In regard to OWI, Your Honor.
Okay, you understand that a guilty plea and this could result in impact to any travel or immigration status that you may be seeking in the future.
Yes, Your Honor.
It can also be a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Okay.
As to count one, malicious destruction of personal property less than 200. How do you plead?
Guilty, Your Honor.
You are agreeing to forfeit a firearm not related to this charge, but related to file number 24-0062.
Yes, Your Honor. The police department already has that firearm.
I recognize you're in custody, but you agreed to forfeit it,
Yes,
correct?
yes.
Okay, and then you also are agreeing to pay a restitution in the amount of $846.54.
Yes, Your Honor.
Okay. Factual basis, please.
Thank you, Your Honor. Mr. Ellenboss, on or about October 8th of 2023, were you at 122 South Hosmer here in the city of Lansing?
Yes.
And that's in Ingham County, correct?
Yes.
And did you at that time scratch and damage a truck belonging to Hunter Man Docking?
Yes.
No further question.
Any questions from the prosecution?
And when you damaged that vehicle, you did that on purpose, correct?
Yeah.
No further questions.
And the amount of the destruction or injury was less than $200?
Yes.
The court is satisfied with the factual basis, how accept your plea, and find you to be voluntarily and intelligently. You can make allocution. Actually, is the victim here?
The victim is here, right? He's on the hall. Can I get
Yes,
him?
please.
Yeah. This is Mr. Mandoki, so.
Okay, is he gonna give a statement at all?
I wasn't sure if you wanted to or not. I know typically you do defense first and then station, so.
Okay, you can make allocution.
Okay. Mr. Ellenboss is currently at Holden House, Your Honor. He has been dealing with substance abuse issues that were aggravated by the divorce that he was going through. Found himself in a position where he was homeless. It's actually a large part of the reason that him and Mr. Maynard came into contact. He was crashing there for a minute. Mr. Ellenboss does not at all deny that he is culpable in this event, that he has made several mistakes during this period of his life. That's why he is in recovery. That's why he has plans to move to the reporter house after that and be gainfully employed and a functional member of society, as he at one time was. But he admits that he has issues that need to be dealt with, and he is in the process of dealing with those, and asks the court just to consider that in whatever sentencing court is.
And the victim's center doesn't wish to make a statement.
I decided to move to immediate sentencing because I just put this gentleman on probation of less than a month ago or about a month ago for this board. He'll be on probation under my supervision for the next year. So it's not meaningful for me to send him to have another pre-sentence report because it's not going to be much different from the last one I just had, and I can't duplicate his supervision before me. So your order would obviously be to continue in your probation and to not violate my order. You're going to forfeit your firearm as part of this plea agreement, that you're going to pay restitution to the victim in the amount of $846.54. You're going to pay a court fine in the amount of $300 plus $75 crime victim rights, $50 state minimum costs. And I recognize you are currently at the Holden House, but you're going to want to be looking for some employment because you got some bills to pay.
Yep.
Understand that?
Yes, Your Honor. I'm already set and accepted at the reporter house as soon as my completion of the Holden House is done. That's definitely going to be something I'm going to be doing sometime.
So 425 and court cost was 846.54. It's a total of $1,271.54. How long are you going to be in Holden House?
At least that is to be determined. I'm already accepted and I have a bed waiting for me at the reporter house. The staff there is discussing whether or not they're going to be doing my completion early and allowing me to move on, or if they're going to be holding me for continuing to treat me for the full 90 days. The full 90 days would be up at the beginning of July. But they have to discuss whether or not they're going to be completing me early sometime soon.
Okay, when do you think you're going to begin making payments on this?
As soon as I'm able, at the latest, it would be after I'm able to get a job at the three-quarter house beginning of August. They generally don't like you to get a job as soon as you get into three-quarter housing. It takes time settling things.
I'm going to know that you're going to begin making payments by August 15th. You'll contact the court, and obviously you're under court supervision, then another file. So we'll be in contact with you with a show cause if you don't notify us by August 15th of any arrangements that you need me, okay?
Of course.
Okay. Any additional matters for the record today?
Some people.
Thank you. And let's see here. Actually, that file. So that's being dismissed. You're all set, sir. On the record in the matter of the people of the state of Michigan versus Tiana Willard, file number 24-00485. Council Simmons.
This is the prosecuting trust and have people.
When you are Joseph King on behalf of Ms. Villiers, who is president to my left, not my right. Sorry.
No problem. Okay, how are you, ma'am? Yeah. Well, thank you. Same date, time set for a final pretrial. The necessary witnesses fail to appear. The people are moving to dismiss this case. However, they are objecting to destruction of your arrest records under the statute. So you have the right to reissue this charge against you. Do you understand that? Do you have any questions about that?
What is the destruction department?
So your arrest records would include your fingerprints and the fact that you were arrested. They don't want that destroyed, probably because they believe they're going to likely reissue if they make contact with the victim that did not appear today. You have any other questions?
Yeah, we share a child together, so do I just not have any contact with him?
The no contact order is over as leave on this file, unless you have another one that I don't know about. This one is being dismissed today, so the no contact order is also going to be dismissed, but you need to wait at least 72 hours before you do anything that would cause the police to be involved, because we got to get that no contact order out of the system. So I'm not telling you that you can't have contact with them in the next 72 hours, but you want to definitely make sure there's no by misconstruing the contact as anything but peaceful, because that is still in the system until they take it out of you, okay? We'll get your copy of the dismissal in just a moment. Any additional matters for the record?
Nothing, Your Honor, thank you.
Okay, you're all set.
Thank you.
On the record in the matter of the people of the state of Michigan versus Lindsay Overbeck, file number 24-00310, council appearance.
This is the prosecuting trust and have people.
Jake Ryan, on behalf of Ms. Villiers.
How are you, Ms. Overbeck?
I'm good, how are you?
I'm doing well, thank you. Okay, so it was the date and time that was set for a final pretrial. But the necessary witnesses fail to appear. The people are moving to dismiss this case without prejudice. So the case will be dismissed. You have the right, however, to reissue the charge against you, okay? You have any questions? your copy of your dismissal. I need some additional matters for the record, counsel.
Nothing from people.
Nothing for the defense, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Makila and Delisa Mead, file number 24-00271.
Assistant prosecutor Casey Chasky on behalf of the people.
Take a rally on the misdemeanor.
How are you, Ms. Mead? Good. Is the date and time set for final pretrial. The necessary witnesses failed to appear. The people are moving to dismiss this without prejudice, but they are objecting to this destruction of your arrest records under the statute. Okay. I can hear you. Okay. Yes. You have a question?
I'm trying to, when you explained to her before, because I turned myself in, and it was a false.
I understand that, but that has nothing to do with why they're objecting to the destruction. I think it's pretty standard for any domestic or assaultive action right now.
How long is that?
How long is the destruction that they're? How long will you be holding these records, or can she ever have them removed or sealed?
My apologies, I don't know if I can find out.
Valid question.
Records like this, so.
The fact that we have your arrest record, meaning that you have a fingerprint and you've been arrested and charged with this, that's what they're objecting to at this time. Destroying that, but the case is dismissed. And they do, because it's dismissed without prejudice, meaning you've not been prosecuted for it, that means that they do have the right to reissue the charge. So if the complaining witness contacted them and said, I missed court, but I want to have my court date, they do have the authority to reissue that charge against you. That's what I mean by without prejudice, okay?
Sorry, the actual statute that the objection is under does not contain how long it is set for. So,
I would advise you counsel with your attorney about what your recourse is when there is an objection to the destruction, because obviously they can only reissue the charge for the statutory time frame. So there's no reason why they need to hold these records indefinitely for you. I think after a reasonable time frame, you probably can make efforts or make a motion to them to destroy those records, okay? All right. And you can talk to him about how you would do that, because obviously you don't intend to stay in regular communication with him, I hope. And so get that information now so that at the time that's appropriate, you can submit that paperwork and they can make the destruction available to you, okay? If you have any other questions at this time, we're gonna get your copy of your dismissal and you're free to go. Thank you. I saw Mr. Booth, but he might have stepped out. Okay, on the record of the matter of the people of the state of Michigan versus Cameron Jamil Fair, file number is 23-02131. Counsel appearance.
Assistant prosecutor Casey Chasky on behalf of the people.
Good morning, Your Honor. Dustin Coons for Cameron Fair. I'm here in the courtroom. He's attorney by Zoom.
Mr. Fair, can you hear us?
Yes, ma'am.
Okay, today was the date and the time that was set for a pre-trial. We got one count for weapons, firearm possession under influence, and count 2 weapons, firearm, careless discharge, property damage. How are we proceeding on this?
Yes, Your Honor. I spoke to Mr. Trusky about the case. There is a plea offer on the table. I think this particular case presents some interesting legal issues, though, that if my theories are right, I don't believe the prosecution could move forward. So I'd be seeking a motion date if final trial is court.
And what's the offer?
The offer is for Mr. Fair to plead guilty to count 2, careless discharge or property damage to the other less of a firearm, and forfeit the firearm, and we would dismiss count 1, the possession under the influence.
And I believe there would also be a recommendation.
Oh, yes, yeah, and as well as a sentencing recommendation for no upfront jail.
Okay, when do you intend to file your motion?
Your Honor, if I could just get a motion date, that will be track to. I don't need much time to draft it, I think.
I gotta give her time to respond.
Of course.
I gotta have time to read it. Because I typically get a response the week it's due, and people, guess I sit around waiting for responses. That's why I don't know how much time you need to file it. But if you don't need much time, get your next court date.
That is June 18th at 10:30.
June 18th at 10:30. I expect that there will be a motion filed that gives her 14 days notice or time to respond. Okay, any additional matters for today's record?
I don't think people.
No, thank you, Your Honor.
And you're gonna have a hearing date, but your client doesn't live here, so he's gonna appear via Zoom for that hearing.
If the court would allow it.
And your final pre-trial as well, right?
Yes, sir.
I'll put that after the June 18th date. Final pre-trial, July 9th at 8 a.m. July 9th at 8 a.m. Final pre-trial of the defendant and the victim to appear via Zoom.
Here, and the trial August 6th at 8.
August 6th at 8. For jury trial, parties must appear in person.
For the point of clarification, I don't believe our motion will require an evidentiary hearing. That's what I think right now. Mr. Trusky made this reading. I indicated in the motion.
Okay, sounds good. No problem. Any additional matters?
I think people.
We'll your notes to be. On the record, in the matter of the people of the state of Michigan versus Eduardo Domingo Alejo, file number 24-00573, counsel appearance.
Assistant prosecutor Casey Chasky on behalf of the people.
Jacob Riley, on behalf of Mr. Alejo.
Okay, today's the date and time that was set. A trial for one count of domestic violence. We need to proceed on this.
My client will ask that this may be set for final trial dates.
Well, Was that the Chronicle report? He was in Stonecrest, is that where he was? Okay. Witness appear?
Well, the witness did as a last court date, which was on May 7th. So she was excused from appearing today.
I have no here that she did not need to appear, so this matter will be set for jury trial. August 13th at 8 a.m. in person at the court. You have any questions today, sir? Any additional matters for the record? You're all set, sir. Back on the record in the matter of the people of the state of Michigan versus the Jimmy Cunningham. And Mr. Lee, your request was for permission for her to go to the address of 3017 Forest Road.
That is correct.
For the purposes of doing what?
Retrieving personal property that she has in the home. That is the home that they were sharing prior to allegations upon the issuance of the no contact order. Ms. Cotton did not go back to the home and retrieve those items. And if you read the message, then you know he's going to be leaving that property, will not be leaving there, or rather living there anymore. So he's got to be out in a couple of weeks, and he said this weekend, Memorial Day weekend, will be a good opportunity for them to come pick up her stuff. She has a church group that is volunteered to help her in that endeavor.
He said he'll be here Memorial Weekend.
Yes, he'll be there on Memorial Weekend and available to assist if anything is necessary. I think what they really need to do is just call him and let them know what time they will be coming there so that he can make sure it's open and available to them. I think he should leave the property, let them get the stuff, and then or have the police there or whatever, logistics need to be worked out. But I agree with you, it would not be appropriate for him to hurt them.
Was your office been in contact with him?
Yes, we have. I know we haven't spoken specifically about this issue.
Okay, well, I'm going to require the prosecutor to reach out to him. I don't know who this text message is from. I can easily put a number in my phone and say it was from anybody. So I need the prosecutor to verify that he is okay with not being there so that she can go get her things, or that he can work with a third party for the purposes of getting her things.
And I don't. I haven't dealt with this specific issue in some of the counties. I know in other counties, it's been standard practice to have an officer go with the individual to retrieve their property on civil standby. So I would just after obviously confirm everything with the victim if that's how it is.
Yeah, that's typical in their bond conditions. I don't know. I didn't read her, so I don't know. Let's see if that was in there. That was not granted as part of her bond conditions. However, if you can confirm that he's not going to be there, this message, at least what I see, says it's from April 1st.
Yeah, I will confirm that, and I will notify the court.
Okay, let me know, and then I can amend the bond so that she can go one time with law enforcement to get her things, or he can confirm that he won't be there. You can also ascertain if he intends to come to court for our next court date, so we're not wasting people's time. If he's not, then we can free her of her life. We doesn't need to tie up the court. But we can't hold this over and call the police for bond violations and then send text messages too. We can't do everything. So I'll let the prosecutor do their diligence and flush that out, and they can notify me and we'll handle it accordingly. I need additional matters for the record.
Thank you.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Anthony Devon Price, file number 23-03212, counsel appearance.
Mr. Prosecutor, please have people.
Jacob Riley, we have Mr. Price.
Okay, today is the date and time now set for sentencing. I do have a pre-sentence report and recommendation dated prepared May 10th, 2024. Counsel, did you get a copy of that?
He did not, yes.
Yes, Your Honor.
We need to make changes to update resolutions.
No, Your Honor, I believe the report is accurate.
No, edits from the.
Make the application.
Your Honor, I think the recommendations of the report are rather fair. I think so. I think it's a benefit from founding resolution and what you mentioned, counseling. So we separate himself from a contentious situation with his neighbors. It's not a situation he wants to be in ever again. I think this is going to avoid that. He should see in this court, this sort of issue again. Going forward, I think he's committed to sort of developing better ways to deal with conflict and interpersonal issues. It's like,
Thank you. Did you probably want to make a statement at all? What's going on with these pending detainers warrants? Make a statement about that.
Insurance on my car.
Yeah, what's going on? Did you pay it?
Big going for it. Been a lot going on. Trying to get back on my feet. Like,
Are you working?
all right. I'm trying to find a job. It's kind of hard to find a job.
You said your dialysis? Okay. But you were working, I thought, previously, at least at the time of the election.
I was, but this case didn't lose my house. Pretty much everything.
So you have some warrants in 64A, 65A.
Well, I think
And they're willing to pick up within 50 miles, so they want their money. So what are you gonna do about that, sir? I understand that you have some health conditions, but you also have some children and some legal matters, which if these are set for show causes, that means they've been lingering for a while. You gotta make some kind of communication with that court and a payment arrangement of some sort. You can't just let it linger, and anything can happen. You make police contact, and you're in jail because you owe money. You don't want that. You call and you say, hey, I got this failure to appear for show cause. Show cause just means you come and show us why you didn't pay. I lost my job. I have a health condition that's preventing me from getting gainful employment. I need some time. It requires you to take responsibility to make that communication so that you don't walk out here, make unexpected interaction with law enforcement, and then you're picked up and transported 50 miles away because you owe a fine. Okay?
Where's it located? I don't know.
64A and 65A. I couldn't even tell you where those courts are. I'll let your attorney look those up.
it looks like 64 A's Iona and 65 A's Lincoln County, St. John's.
Well, you look like you didn't pay a fine from there, is what it's saying. I don't know that you say you've never been to St. John's. I have one here, 10/29/2018, in your criminal history report, that you were allegedly charged with the domestic violence in that county. It was dismissed or nolly, but you were at least charged. Oh, now see how that refreshes recollections, right? Yeah. And then 64A, June 22nd, 2021, misdemeanor motor vehicle operate without security. You pled guilty. You didn't have insurance. That's what you say. You didn't have insurance. That's what that one's for. So you owe them some money. And these are kind of old. They want their money. And you got to make arrangements so that you don't get, because 65 they said, whereas 64 is willing to pick you up within 50 miles. 65 said, we'll give you 100. They want their money. So you're going to need to find something that you can do part-time, whatever, because you still got to make a living for yourself and for your children, which your children were the basis of your defense in this issue, correct? That you were protecting and providing for your children. And so you still need to do that. I remember the trial. I found it to be an unfortunate series of events, but the jury made the decision that they made. And so regardless of the circumstance that you may be placed into as a father, you still have a responsibility to follow the law and to resolve matters in ways that comport with the law. Even if you believe that you were sufficiently provoked. But nonetheless, I believe that you would benefit from participating in an anger management program, but I think you would benefit most by getting a job.
Yeah, I ain't got no problem.
I would say that a reflection of your criminal history does not necessarily agree with that. There has been at least 2 other charges of assaulted action, no conviction, but charged.
Yeah, that's good.
But I don't want to hear anything about what that does, because I also know from the vantage point that I have that lots of domestic violence are charged. The victims don't appear for various reasons. A lot of times they got back with the person that they have alleged domestic violence against, or they just don't feel it's worth it. Either way, you have been at least charged with assaulted actions on more than one occasion in different years, 2018, 2021, and then now a conviction of an aggravated assault, or an assault and battery, I should say, in 2024. And so you would benefit from some resources and tools to help you to avoid having further charges brought against you for similar action, don't you think?
The application center, give me a second. I think that's what you said before work.
You said, are you gonna put it where?
Somebody have.
You don't know what the name of the rehab center is?
No, I just know somebody have.
Okay.
I don't do drugs, man. Just like
You're applying, you're going for a job placement? Is that what you're
yeah,
going
they're gonna send me back. They'll try it to send it.
for? You're on disability? Is that a yes? I'm going to order that you complete an anger management program and provide proof of that to the court within 60 days. And bring proof that you've been looking for employment. I'm not going to put you on probation. I just want you to do the anger management. I'll give you a date for you to come back for that. Give me 60 days, please.
July 23rd.
July 23rd at 10 a.m., okay? Okay, do you have any questions? Any additional matters for the record?
And the people.
Nothing from the defense.
Yes, sir, we're clear, I haven't sentenced you yet. I said reset the sentence for that for you to do that. So come back without it and see what happens. Have a good one. Sarah Holly. On the record in the matter of the people of the state of Michigan versus Terrence Devontae Maurice Holly, file number 24-01357. Council hands.
Mr. Prosecutor, you can on behalf of people.
Jacob Rowley, on behalf of Mr. Holly.
Okay, Mr. Holly. It was a date that was set for a pre-trial. This is for domestic violence, but now I have a bond violation. Allegation that you violated the terms and conditions of your bond by making contact against the no contact order protecting Jessica Redmond. So you have the right to have a contested hearing on the bond violation or the allegation that you violated your bond. You have the right to be represented by your attorney at that contested hearing. If you're found to be in violation of your bond, you're facing 90 days in jail and or a sentence of $7,500 in fines. Do you understand that? So you want to address that?
Your Honor, Mr. Holly will plead guilty to the violation.
Is that correct? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give the truth and the whole truth under penalty of perjury? Okay, so you understand that you do have the right to have a hearing on that and require proofs to be brought forth that would sustain the violation. You don't have to plead guilty. Do you understand that? You want to waive your rights to the contested hearing and enter guilty to the violation? Anybody threatening you to do that? Any promises being made to you if you plead guilty to the violation? As to the violation, that you violated your bond conditions, say on or about May 10th, 2024, by making contact with the protected party, how do you plead? Actual basis.
Mr. Holly, is it true that you were arraigned on May 4th of this year for this case? Is it true that you were placed on bond? It was one of the conditions of your bond that you were not to have the right to make direct contact with Jessica Redmond. It's true that you violated those bond conditions by having direct contact with Jessica Redmond on or about May 10th.
Additional questions?
No, Your Honor, thank you.
Okay, the court is satisfied with the factual basis. I would accept your plea to the bond violation of finding to be voluntarily and intelligently made. Is he on remand because of this?
Partly because of this, Your Honor, it also has a pending circuit court probation violation set for a hearing on Thursday, the 23rd. Sorry, Wednesday, the 22nd.
How are we proceeding in the underlying issue?
Mr. Holly also has a felony case that's being handled by Assistant Prosecutor Mr. Adam Pfeiffer that I believe is in the process. It's in the early stages. Still a district court. So at this time, there's not an offer in this file, but it's my I anticipate that this case will be wrapped in as a part of a full resolution of that file.
How do you proceed?
Likely possibility, or I should say likelihood that the case being arraigned in separate court dates in the near future, I would request that the second pretrial conference.
June 25th at 10. To make allocution on sentencing for the bond violation.
Your Honor, certainly, Mr. Holly, exercise court judgment by violating the conditions of the bond soon after this arraignment in this case. Already want to know that to my knowledge, there is no allegation of any kind of assault or threatening or harassing behavior in connection to this violation. Mr. Holly certainly needs to be aware and be careful about abiding by those bond conditions. Certainly, if the GPS fed work, he would have a problem with that. But certainly, if he has been in custody for a week on this matter, he has that certain court probation. Request that he be allowed an opportunity for a pretrial release.
This is not a bond violation. This is a sentencing on the bond violation. This is not the motion for his bond. I don't care what he would be open to. He was supposed to follow the court order. I don't care if the contact is not alleged to have been assaulted or threatening. We didn't say that you're not allowed to have any assaultive or threatening interactions with the victim. We said no contact at all. And he violated it. What is supposed to make me believe you're not going to further violate the court order when less than a week goes by and you're already in violation? What's he on probation for?
I can pull that file that I have open at this moment.
What you got an alleged violation? What's the alleged violation?
Please for a report after a month.
He doesn't follow court orders. Sentenced to 30 days in county jail on the violation. Bond in the underlying matter will now be 500 cash shorty with GPS tether. You're not to be within 2,000 feet of wherever the victim is. You're not to have contact of any kind, of any nature, directly or indirectly. Do you understand what direct contact and communication means? You understand what indirect contact and communication means? We'll see you at your next court date for your pre-trial June 25th at 10 a.m. Any additional matters for the record?
Just what was the bond amount modified to?
500 cash shorty with GPS tether.
And then nothing further.
Nothing further.
You're all set. Go back and price this last. Vision and Riddle.
Your Honor, I received a message from Mr. Riddle's father this morning, indicated that Mr. Riddle had been assaulted over the weekend and was taken to the hospital. I don't have any further updates as of yet.
He's already on. He failed to appear on his last court date. My last note was May, April 22nd. Revoke bond, remand to see judge because he failed to appear.
That was didn't charge. Well, I put in words. You told me to, where he didn't charge if you could set it.
Yep, that was on the 22nd. Yeah, I haven't got any notice that was fixed. So he's already on, his bond is already revoked.
Over. Mr. Green reached out yesterday, just saying that she's in the county, so. She's
County? June 18th. May 21st.
Oh, this one's saying 26.
Okay. Diana Zimmer?
Ben.
Interfere?
Okay, yeah.
Up to Diana Zimmer.
Yeah, yeah. I'm sorry.
Trying to get some special dog service. Ms. Zimmer? You have a number?
Any number, but it appears to be unservice.
Yeah, maybe a second. I got a couple cases on down before.
Oh, for the.
For Kansas, yeah.
Okay.
Right.
They're in the document.
Oh, okay. And, there's one though. There's one right now, but that one, I put not sure, so. There's no court record for that. Also, I just dismissed her system.
She's a senior citizen. This is a dog at large case. I'm gonna reset it. I cannot input conscious bench warrant her for that. She might have forgot.
I'm here.
Oh, who's on? I'm looking for Ms. Zimmer.
Not me, sorry.
Okay, thank you. We'll send her a notice and see if she comes. So, Mr. Riley, we're gonna send her a notice and see if she comes. Who's TMO's iPhone?
Judge? Ah.
Hi, Mr. Blackman.
Good morning.
Okay, and then someone is on, it says TMO's iPhone. What's your name? Hey. Hey. I'm sorry?
Amir Jernigan?
Oh, okay, thank you. Who's representing Mr. Jernigan? You need to speak to him? Okay, and then Mr. Blackman, are you ready, Ms. Davies?
I believe so. Judge, can I have a breakout? I was just looking at an email from Paige, so if I could talk to my client real quick, on a breakout, I would appreciate it.
Okay, 1 second. I'll cover the date for Zimmer. June 25th at 9. Then, let's see, on the record, in the matter of the people of the state of Michigan, first is Amir James Jernigan, file number 24-01105, council appearance.
This is the prosecutor asking about people.
Jacob Rowley on behalf of Mr. Jernigan.
Okay, Mr. Jernigan, today's date and time set for pretrial. I got count 1, domestic violence, count 2, assault and battery.
Yes, ma'am.
Okay, and then you do have counsel now. Was there an offer on this, prosecutor?
Yes, there was. If Mr. Jernigan were to plead guilty in count 1, people have no objection to 76940 status that he's eligible and we would dismiss count 2.
Pretrial. Okay. It's 13. 13. Okay, your final pretrial is going to be July 9th at 8 o'clock in the morning in person at the court. Jury trial is currently scheduled for August 13th at 8 a.m. in person at the court, okay?
Yes, ma'am.
Do you have any questions today?
No, he said this is in person. It says June the 9th, June 8th, I mean, July 9th.
Yep, July 9th is in person and August 13th is also in person.
Okay.
Any
Yes,
other questions, sir? Okay, and
No, ma'am.
then you're all set. Thank you.
Thank you.
You're welcome. Okay, Mr. Blackman, are you ready?
We are.
Okay, on the record in the matter of the people of the city, I'm sorry, people of the state of Michigan, I saw the dog licenses and messing up in there. File number of person Jocelyn Davies, 24-00433, 24-0043, 4435, and 436, council appearance.
Assistant Prosecutor Peter Trusty on behalf of the people.
Your Honor, Fred Blackman on behalf of Ms. Davies.
Okay, it was the date and the time set for pre-trials. I have a dog malicious destruction of property, and 3 dog at larges. How are we proceeding?
Your Honor, if I might, I received from page a plea offer. My client will be pleading guilty. My client will be pleading guilty to one of the counts of dog at large, pay restitution if there's any restitution. It's my understanding the other counts will be dismissed.
Okay, I don't know where your client is. Push it up. Of course, it doesn't mean you.
I'm
You also don't get to talk over me. You also don't get to talk over me in virtual court either. And so you need to be stationary and ready to proceed with the trial. Your attorney is advising that you're going to take a guilty plea to a criminal action. So you probably don't want to be talking to someone else right now. Okay. Okay. So she's going to plead to what, counsel?
What are the dog at large counts, Your Honor?
That's right. She'll be pleading to one of the Docket large counts and agreeing to pay restitution. I tried to contact the victim to get a number or an amount for the restitution, but I heard she wasn't able to. She didn't pick up when I called. So I will be trying to get that restitution amount and Mr. Blackman as soon as possible.
Thank you.
So we need to set that for a restitution hearing.
That's right, Chair.
Any particular dog at large count that you needs to plead to?
The people have no position on it.
Okay, Ms. Davies, you can undo your device. You want to plead guilty today to 1 count of dog at large and pay restitution?
Yes.
Okay, and as a way of agreement, the other charges will be dismissed?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, so you can put your hand down. You have several rights that you need to first understand and that you need to give up in order to accept this offer. First, you have the right to the presumption of innocent. You are presumed to be innocent until proven guilty. Do you understand that?
Yes.
You have the right to require the prosecution to prove your guilt at a trial. You have the right to a jury trial. You have the right to remain silent at your jury trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses that the prosecution calls to testify against you. You have the right to call your own witnesses to testify on your behalf or present evidence that you believe show defense to the charge being brought against you. You can waive your right to silence at trial and testify on your own behalf. You understand all those rights and you're willing to give all those rights up today?
Yes.
Threatening to get you to plead guilty to 1 count of dog at large.
No.
Has there been any promises made to you when you enter a guilty plea?
No.
You're agreeing to restitution being paid in this case, but you don't know how much the restitution is. Is that correct?
Yes.
Okay, so we're going to set it for a restitution hearing, and to the extent that an amount comes in that you disagree with largely, then we will address it by way of hearing. As it pertains to file number 24-00436. Dog at large. How do you plead?
Guilty.
Factual basis, please, counsel.
Thank you, Your Honor. Ms. Davies, let me take
Yes.
you back. Let me take you back to on or before March 5th of 2024. Were you in the city of Lansing County, Bingham, state of Michigan?
Yes.
You owned at least how many dogs did you own?
4.
4. Okay. On that date and time in question, did your dogs break out of your fenced yard?
Yes.
Okay, and they were running at large in the community at that point. Is that correct?
Yes.
How long were they out? Do you know?
20 minutes, if that.
Okay, but they were running at large and they were not penned up as they're supposed to be. Is that correct?
Correct.
All right. Your Honor, I have no further questions.
Any questions from the prosecutor?
No, Your Honor, thank you. And I know Mr. Blackman's not present, but I do have a plea sheet filled out.
You can sign. I give you permission to sign my name to it.
Thank
Thank
you.
you.
Oh, no fee is due. Okay, and so we'll set this matter for sentencing and restitution hearing. June 25th at 9 a.m.
Thank you, Your Honor.
You're welcome to have a hearing. Your client must appear in person.
We will be in prison, Judge.
Okay.
Does she need to go to the probation department at all, Your Honor, or just appear for the hearing?
Nope, she does not. I'm not referring to probation for a dog at large.
Okay, thank you.
Thank you. Any additional matters for the record?
Nothing for the people.
Nothing for the defense, Your Honor. Thank you.
You're all set.
Thank you.
You're welcome. No, I don't need to bring it to the. Did we take a plea for Tiffany already? Is that what happened? I don't remember.
Typical case, I think Judge retains the drug court, and so
We took a plea there. Is that
yes,
correct?
yeah.
Okay, yeah, we don't need to bring her up. I just need Judge Ward to sign this on behalf of Judge Buchanan, and then that case will be all set today. And then, so the rest of the days. Yeah, Ms. Berkeley. You have Jernigan here, or Armstrong? Last name? You're Armstrong. Where's Mr. Yang? I saw him. Oh, you fine. the matter of the people of the state of Michigan versus Cheyenne Armstrong, cause number 24-01376. Council appearance.
Council Lee Johnson, on behalf of the people.
Morning, Your Honor. Joseph Yang on behalf of Armstrong, is president to my right.
Okay, Ms. Armstrong, today's date that's set for a trial, one count of attempted police officer assaulting, resisting instruction, count 2 retail fraud in the second degree. Still an offer on this.
There is, Your Honor, offers for Ms. Armstrong to plead guilty to amended count 1 of disorderly person jostling with no objection to HIDA and dismiss count 2.
Your Honor, I have extended the offer to Ms. Armstrong. She'd like some time to review that. And so I'd ask for a final pretrial to be set. I don't believe there are any other pending discovery issues at this time.
I'm not requiring a witness to come, so we can set it for final pretrial.
Yeah, yes, Your Honor. I want to set a final pretrial as kind of a deadline for the offer so that we know how we're going to go with this case.
June 25th at 8 a.m.
That works for me, Your Honor.
You'll appear in person for that, and then you'll have time to consider the offer and discuss that further with your attorney. Do you have any questions to report today? Any additional matters for the record, counsel?
Nothing further, Your Honor.
Nothing.
You're all set.
Thank you.
Thank you. I don't know. Were you waiting for a case?
Yes, sir.
That's operation that or excuse me, advantage.
Oh.
It's-
Were you with her, sir? Were you waiting for court date? Oh, that's interesting. Okay. We need Mr. Seabrook, because he's my entire concurrent situation. And then Susan. Smith. You're representing Mr. Smith?
No, Your Honor, this one, confidential, unfortunately, we still not.
So could you represent the co-defendant? So we have to reset this. June 25th at 10. Get your new court date, Mr. Smith. By then, you should have had new counsel and should have met with your counsel, okay? Have any questions for the court? Is he an attorney? Are we ready on the status?
Close, Your Honor. I'm waiting for an email to come through.
And then I'm just gonna hold on. Is this? You're probably cool with that. I think you're- They're fine. So you just like the numbers, email, text messages, something like they don't have stuff. I'll just put that way.
Oh,
So just the 26th.
That was really good. Yeah.
yeah, you have to put the whole.
And you before this is fine.
So I just.
Joshua Zuzman?
Is the right order?
No Joshua Zuzman? Of course, it's a dog case.
Did you do a bench work for Devin Rain? Devin Rain is another dog case from this morning. He was set for. Peter.
No, my docket.
Oh, thanks for that change.
I was gonna say, all these, this is all I got for the rest of the day. And these all belong to Mr. Seabrook.
Hey, so.
Oh, yeah, this was gonna move.
Oh, I'm sorry.
Oh,
Don't have this bar, I'm sorry.
no, you're good. I get it all the time. Sorry about that.
Remove. What is the GPS time? So. Get that next one. Then you put GPS time. Oh, so again. Again, and remember, that's a 4 times.
It's on 17.
Somebody got to clear you out. So we'll just go back to there and get 3 years out. I don't like it.
Here's a-
Hopefully,
That's right.
I will prepare to proceed. Proceed with my- Yes, that's absolutely.
They can't find it. I'm supposed to print them.
Yeah. I think it's too.
Okay, there's a couple of them. Yeah.
Oh, sorry, right.
Just redraw, so.
Okay, that one is still later. Okay, on the record. The matters of the people of the state of Michigan versus Terry Alonzo Seabrook, file number 23-03281, 3282, 24-00608, 609, 610, 24-01023, 1178, 1179, 1180, 1181, 1182, 1183. Council Pence.
Prosecutor Page, Trustee, and half people.
Assistant Public Defender John Leo came on behalf of Kerry Alonzo Seaman.
Okay, Mr. Seabrook, today's date set to address 1, 2, 3, 4, 5, 6, 7, 8 dog at large and 1, 2, 3, 4 dog license vaccinations. Council, how we proceed?
Your Honor, at this time, Mr. Seabrook has begun producing the proofs necessary to come in compliance. He has shown me pictures of remediation that he's making to cure the dog at large charges. He has also shown me 2 out of the 4 licenses. However, I have not yet had a chance to review the licenses. Just received them. And of course, remove proofs on all 4 of the dogs before the prosecutor would feel comfortable dismissing. So we probably need a short adjournment to complete the proofs and resolve issues.
June 25th at 10:30 is your next court date, okay? On these files. So hang tight, you're gonna stand there while I write this note in every single last one of these files. People of the city of Lansing versus Terry Seabrook. He was supposed to be here yesterday. What happened?
I was not understand how.
I can totally understand why you would be confused, why there would be 20 cases today and 1 yesterday. I can totally get that. This has to be reset. There's a reason why this was yesterday. This one's a city case. So a city attorney has to be here. She doesn't work for the city. She works for Ingham County Prosecutor. So we don't have a city attorney to address this. This needs to be reset to a city day. So you can't confuse your city court dates with your county court dates, okay? June 24. June 24, 9:30 at 9:30. Back-to-back dates, okay?
That's right.
And what's your name?
That is Kelly.
Now, what is this court date? Yes. Maybe not. On the record, in the matter of the people of the state of Michigan versus Terry Seabrook, file number 24-01395 SM, council appearance.
Assistant Prosecutor Page, Trustee, and half people.
Assistant Public Defender John Leo on behalf of Kerry Seabrook.
I have a misdemeanor complaint here that alleges that on or about April 12, 2024, at the area of 829 Euclid Place, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of domestic violence. It alleges that you did make an assault or assault and battery upon a Kelly Hooks, an individual whom you had a dating relationship, contract MTL 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 fine. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the maximum penalty? You have the right to be represented by counsel. Mr. Lee, who is representing you in other matters charged before this court, is any here on this matter today for the purpose of your arraignment. You do have the right to have an attorney represent you at each stage of the criminal prosecution and if you're questioned by law enforcement, okay? If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public because you are being represented by other matters, on other matters by the office of the public defender. On the time you will be eligible in this matter, are you requesting representation? Or note that here on the file. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter is going to continue to trial. You have the right to jury trial. And you have the right to the presumption of innocence. You're innocent until proven guilty, and you have the right to require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront and cross-examine any court any witnesses the prosecution calls to testify against you. You have the right to remain silent at trial, not have silence used against you. You can waive your right to silence and testify at your trial if you like. You can subpoena witnesses to testify on your behalf at your trial, and you can present evidence that you believe show defense to the charge being brought against you. Do you have any questions about those rights? For the purposes of your arraignment, the court will enter a plea of not guilty. That will be set for a pre-trial. For me, June 25th at 10:30. The same date as your dog cases, okay? Yes, please. You can have a seat. And counsel, you can get whatever of his belongings that she has because you know there's going to be no contact order. What does the doggone fund trip mean? Oh, okay. I thought that was like a business or something. Oh, okay. But you're not connected to that business. You just thought it'd be fun to record. I would really like that too if I had 20 dog at large cases for the court at one time.
This afternoon, we have 2 probation violation hearings. Would it be okay if I appear to be for those?
Don't we have hearings?
And they're separate hearings. I don't anticipate they'll be contested. One of them is Mr. Hopfelman.
No, the other one is not public, so.
Oh.
Let's see.
I'll double check with counsel, make sure they're not contested before.
Yeah, if they're not contested, you don't need to.
Okay. And then-
Oh, it's the cooler. Okay, well. Please tell me it's on the same citation. It is. Okay, back on the record. I now have people of the state of Michigan versus Terry Seabrook, file numbers 24-01467, 1465, 1466. How many on this record? Okay, Mr. Seabrook, 3 more dog at larges that you were actually scheduled for an arraignment on June 14th, and you obviously were not aware of that. What's your address? That's where you receive your mail? In Lansing? What's your phone number? Okay, I have a citation here that alleges that on or about May 3rd, 2024 at 11 p.m. In the area of South Pennsylvania and East Kalamazoo City of Lansing, Eaton County, State of Michigan, that you did allegedly get cited for 3 violations of dog at large. This is Sarah, 1.5-year-old blonde white husky female, Jazzy, 1.5 tan black husky female, Gray Wolfie, 1.5-year-old tan gray husky, ran at large. Similar to your other matters, you have the right to have a trial because these are criminal offenses. You have the right to be represented by counsel at your trial. You have the right to the presumption of innocence or innocence until proven guilty. All the other rights that I went over in the domestic violence apply in this matter as well, as it relates to the right to confront witnesses and your right to bring evidence that you believe will show defense to the charges being brought against you. The court will enter a plea of not guilty on your behalf. Note that you are requesting court-appointed counsel, and these will be set for a pre-trial on the same date and time as your other matters. Okay. At large? I think these are the dates. Yeah, we're gonna be together. At this point, there needs to be a condition of bond. I might have to order you not to have an animal at this point, just so we can stop having more dog large cases. Is that what we need to do? I'm talking about if I order you not to have any dogs. That could be a bond condition. I'm sorry? Yeah, well, what do you think that the law would do if someone had children that kept running away and disappearing and getting lost? What do you think that the law would do? remove the children from the home? Do you think that? Thank you. Okay, let's see here. You have a matter pending, the 37 sub report. No. It just shows that the disposition was found over. It doesn't show anything else on that, so I'll leave that to your attorney to look into that. Nonetheless, counsel, you can make allocution on the
Thank you, Your Honor. Mr. Seabrook intends to cooperate fully with the court as his appearance here today suggests. There was some confusion about the days and times regarding city cases and state cases. I believe that's been addressed today. His clear understands that he has to appear on Monday, June 24th and Tuesday, June 25th. That being said, Your Honor, he has provided me the alternate address in anticipation of the no contact order for the domestic violence file, and we ask the court to consider allowing Mr. Seabrook to be on his own personal recognizance as this matter is pending.
where's it gonna live?
He intends to stay with his parents at 6487 Green Road. That is in Hazlet, Michigan. Road.
And that's the address. I believe it's on the other file, and it doesn't appear to be getting his notifications there. Excuse me? That's the address we had, 6487 Green Road, Hazlet, Michigan, but you weren't aware that you had an arraignment set on new charges. You receive your mail to that address in Hazlet? Oh, okay. Where are your dogs right now? I said 500 personal recognizance. You're not to be at the address of 829 split. I will allow you to go once to retrieve your dogs and personal items with law enforcement. I reside at 6487 Green Road in Hazlet. We'll send your notices as well. You need to report to all of your court dates. You need to be on time, otherwise it's a violation of your bond conditions, okay? You're not to have contact directly or indirectly with Kelly Hopes while this matter is pending. Do you understand that? You're not to be within 1,500 feet of wherever she is. Do you understand that? You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess drugs unless you have a valid prescription. And you're not to use, purchase, or possess alcohol out on bond, okay? As to the dog at larges, you must keep your dog secure during the pendencies of these matters. It's your responsibility to ensure they're secure. Do you understand that? Each dog at large will be 100 personal recognizance with all other conditions, including your requirement to appear to all of your court dates, okay? You have any questions about your bond? Your next court date, sir. And then what's the one after that? Very good. We'll get your notice to appear in additional matters for the record. You're all set, sir. I think that's the one.
Yeah, let's do for this one, yeah.